Now I am going to dictate a legal passage based on latest judgment of the Kolkata High Court at the rate of 130 words per minute. Let's start. Learned counsel for the parties submit that now the parties have settled their dispute amicably on persuasion of the senior villagers, which was also reduced into a written compromise dated 16/12/2024. It is further submitted that this court, considering the above fact by order dated 3/3/2025, directed the court below to verify the aforesaid compromise, in pursuance of which the court below has verified the compromise between the parties by order dated 3/4/2025. A copy of the same is annexed at page number 6 of the supplementary affidavit dated 18/6/2025, which is taken on record. This fact is not disputed by the counsel for opposite party number 2 as well as learned AGA. Honorable Apex Court in the case of Gansing versus State of Punjab and another within bracket 2012-10 SCC 303 in paragraph number 61 of the judgment observed as under. The position that emerges from the above discussion can be summarized thus: the power of the High Court in quashing criminal proceeding or FIR or complaint in exercise of its inherent jurisdiction is distinct and different from the power given to a criminal court for compounding the offences under section 320 of the code. Inherent power is of wide plenitude with no statutory limitation, but it has to be exercised in accord with the guideline engrafted in such power, viz: within bracket small I, to secure the ends of justice, or within bracket small II, to prevent the abuse of the process of any court. In what cases power to quash the criminal proceeding or complaint or FIR may be exercised where the offender and victim have settled their dispute would depend on the facts and circumstances of each case, and no category can be prescribed. However, before exercise of such power, the High Court must have due regard to the nature and gravity of the crime. Heinous and serious offences of mental depravity or offences like murder, rape, dacoity, etc. cannot be fittingly quashed even though the victim or victim's family and the offender have settled the dispute. Such offences are not private in nature and have serious impact on society. Similarly, any compromise between the victim and offender in relation to the offences under special statutes like the Prevention of Corruption Act or the offences committed by public servants while working in that capacity, etc., cannot provide for any basis for quashing criminal proceedings involving such offences, but the criminal cases having overwhelmingly and predominantly civil flavor stand on different footing for the purposes of washing, particularly the offences arising from commercial, financial, mercantile, civil, partnership or such like transactions, or the offences arising out of matrimony, relating to dowry, etc., or the family dispute where the wrong is basically private or personal in nature and the parties have resolved their entire dispute. In this category of cases, High Court may quash the criminal proceeding if, in its view, because of the compromise between the offender and the victim, the possibility of conviction is remote and bleak, and continuation of the criminal case would put the accused to great oppression and prejudice, and extreme injustice would be caused to him by not quashing the criminal case despite full and complete settlement and compromise with the victim. In other words, the High Court must consider whether it would be unfair or contrary to the interest of justice to continue with the criminal proceeding, or continuation of the criminal proceeding would tantamount to abuse of process of law despite settlement and compromise between the victim and wrongdoer, and whether to secure the ends of justice it is appropriate that the criminal case is put to an end. And if the answer to the above questions is in the affirmative, the High Court shall be well within its jurisdiction to pursue criminal proceeding. Para. From above noted judgments, it is clear that merely mentioning the section of serious offences will not refrain the court from quashing the proceeding if, on considering the material on record, offences under that section is not made out. Para. Considering the fact as well as on perusal of record, it appears that no heinous and serious offences of material depravity or other offences which may affect the society in general are made out. Now both the parties have amicably settled their dispute through compromise, which has been duly verified by the court below. Therefore, continuation of impugned proceeding will amount to travesty of justice. Stop. Thank you.